Federal Judge Andrew H. Stone believed he had Congresswoman Jasmine Crockett cornered. This 73-year-old Trump-appointed federal judge had posed a question designed to destroy her legal reputation instantly. However, what unfolded next shocked every legal professional inside that Dallas federal courthouse. Stone relaxed into his judicial chair, displaying that arrogant grin he'd perfected over decades. The identical expression he flashed while rejecting civil rights petitions and blocking voting access lawsuits. He anticipated this young African-American attorney from Texas would buckle under judicial pressure. Crockett's response didn't merely quiet the packed courtroom. It created seismic waves throughout America's legal establishment and demonstrated exactly why this Harvard-trained lawyer turned federal legislator should never be challenged lightly. Before we explore this remarkable legal battle, please hit the like button and subscribe to stay updated on these incredible political confrontations. Believe me, you'll want to witness how this dramatic encounter concludes. Don't forget to activate notifications, because stories like this highlight why we must remain vigilant about courthouse proceedings across America. That Tuesday morning, the federal courthouse in Dallas crackled with anticipation. News crews crowded the courthouse steps. Journalists murmured expectations about what seemed like standard procedural hearings. Local television networks assigned rookie reporters, assuming this voting rights paperwork hearing would generate minimal newsworthy content. Nobody anticipated witnessing one of modern legal history's most dramatic courtroom battles. The type of confrontation that becomes mandatory viewing in constitutional law classes and spreads virally across digital platforms. The kind of epic showdown that reminds Americans why certain principles demand fierce protection, regardless of opposing authority figures. However, Jasmine Crockett never follows predictable patterns. Judge Stone was about to discover this reality firsthand. Understanding this confrontation's significance requires knowing the individuals involved in this high-stakes legal drama. At 42 years old, Jasmine Crockett embodies everything that challenges traditional power structures. This Harvard Law School graduate established her professional reputation defending vulnerable populations against institutional power before securing election to Congress, representing Texas's 30th congressional district. She dedicated years as a civil rights lawyer, accepting cases that intimidated other legal professionals. Crockett's childhood in St. Louis, with a single mother juggling multiple jobs, taught her the value of persistent struggle. Her congressional journey wasn't inherited privilege, but earned through countless hours in legal libraries and courtrooms where she frequently stood as the sole black woman present. What makes her formidable to establishment figures like Judge Stone? She refuses intimidation by titles, judicial robes, or institutional reputation. She's confronted hostile judges previously and never retreated when justice required advocacy. Congressional colleagues frequently observe that Crockett doesn't simply enter spaces, she commands them. During her civil rights practice, Crockett earned recognition for absolute fearlessness in legal proceedings. Fellow attorneys warned her about challenging judges, aggressive opposing counsel, or seemingly impossible cases. Her consistent response remained unchanged. "I didn't struggle this far to surrender now." She built her legal career, accepting cases that terrified other practitioners. Voting rights violations that appeared too complex for successful prosecution. Discrimination lawsuits that wealthy defendants assumed they could suppress through expensive legal teams and procedural delays. Civil rights violations occurring in tight-knit communities where speaking truth meant risking everything. Crockett flourished in these challenging circumstances. She possessed exceptional ability to identify overlooked legal arguments, forgotten precedents that transformed cases, and constitutional principles that dismantled opposing defenses. Judge Stone represents the established system Crockett has challenged throughout her career. This Trump appointee from 2019 built his reputation as a prosecutor who consistently dismissed civil rights litigation. At 73, his extended judicial tenure convinced him that his authority remained unquestionable. Stone descended from generational Dallas wealth. His grandfather served as federal judge. His father served as federal judge. He always viewed the judicial appointment as family inheritance. His reputation for sharp commentary and intimidating young attorneys became legendary, particularly those challenging his decisions. Stone's civil rights case approach terrified emerging legal professionals. His standard procedure involved questioning attorney qualifications, attacking their motivations, then dismissing their arguments as political activism rather than legitimate legal advocacy. The legal community shared whispered stories about Stone's courtroom behavior for years. Stories about young Latina attorneys leaving his courtroom in tears after he suggested they master English before practicing law. Black male attorneys threatened with contempt citations for speaking at normal volume. Female attorneys lectured about knowing their place when objecting to his rulings. These incidents weren't isolated. Stone demonstrated consistent patterns of dismissing civil rights cases without hearing complete arguments. He discovered procedural justifications for throwing out voting rights lawsuits. He ruled that discrimination victims failed to prove their cases before allowing evidence presentation. He regularly lectured attorneys about wasting judicial time with political cases. This wasn't routine court business. Crockett represented constituents in voting rights litigation potentially affecting millions of Texans. Stone had already demonstrated hostility toward the case through bench comments legal experts found deeply concerning. The broader implications exceeded this single case. This confrontation would determine whether young, progressive attorneys like Crockett could receive fair hearings in federal court. It questioned whether judges like Stone could continue intimidating civil rights advocates. The legal community watched intently. If Stone successfully humiliated Crockett publicly, it would message every emerging attorney: maintain your position, respect established authority, and avoid challenging existing systems. Stone believed he controlled all advantages. He possessed the judicial robe, the gavel, and 4 decades of experience crushing overconfident lawyers. He underestimated facing someone who had battled bullies throughout her entire life. The courtroom atmosphere grew tense as Judge Stone called proceedings to order. His voice carried that familiar hostile edge experienced court reporters immediately recognized. This hearing wouldn't proceed cordially. "Counselor Crockett," Stone began, emphasizing her title with obvious contempt, "I've examined your motion and must express concern about the legal reasoning presented to this court." Crockett approached the podium, her navy business suit immaculate, her posture radiating confidence. "Your Honor, I welcome addressing any concerns the court maintains about our civil rights petition." Stone's eyes narrowed menacingly. Here came his opening attack. "Civil rights petition, Miss Crockett. Are you aware this court maintains extensive experience handling frivolous civil rights litigation?" The courtroom temperature seemed to plummet. Veteran attorneys in the gallery exchanged worried glances. Stone was revealing his prejudice, dismissing the case before hearing arguments. "Your Honor," Crockett responded smoothly, "every case deserves evaluation based on its individual merits, regardless of the court's historical decisions." Stone's jaw muscles tightened. This young woman wasn't retreating as he anticipated. "Let me pose a question, Counselor," Stone continued, his voice growing sharper. "How many voting rights cases have you actually litigated in federal court?" This represented classic intimidation strategy. Stone attempted to establish that Crockett lacked sufficient experience for his courtroom. "Your Honor, I've successfully litigated numerous civil rights cases, including multiple voting rights matters at state court level," Crockett answered calmly. "State court level," Stone repeated, allowing the words to hang like accusations. "This represents federal court, Miss Crockett. We operate under elevated standards here, standards requiring substantial experience." Complete silence filled the courtroom. Even the court reporter appeared uncomfortable as Stone's hostility became undeniable. Your Honor, I maintain complete confidence in my ability to represent my clients effectively before this court, Crockett replied firmly. Stone leaned forward, believing he had cornered his target. Let me inquire about your clients, then. These voters you claim suffered disenfranchisement. Have you personally verified their registration status? Have you confirmed they were actually prevented from voting by state requirements? This loaded question was designed to make Crockett appear unprepared. If she confirmed verification, Stone would demand proof. If she denied it, he'd accuse her of bringing frivolous claims. Your Honor, we possess comprehensive documentation supporting each client's claims, Crockett replied. Documentation, Stone repeated mockingly. That wasn't my question. I asked whether you personally verified these claims, or are you simply accepting their statements? The implication was unmistakable. Stone suggested Crockett was either incompetent or dishonest. Everyone present recognized what was occurring. This wasn't legal proceedings. It was attempted public humiliation. Stone was trying to destroy Crockett's credibility before the entire legal community. Several gallery attorneys looked uncomfortable. Some whispered about Stone's obvious bias, but nobody spoke up. In Judge Stone's courtroom, you remained quiet and hoped to avoid becoming his next target. Furthermore, Stone continued, his voice rising, I'm troubled by language in your brief. You reference systemic discrimination and historical disenfranchisement. Are you suggesting this court has been complicit in discrimination? Stone was making this personal, baiting Crockett into statements that would justify contempt charges. Crockett paused momentarily. Everyone held their breath. Would she retreat? Would she apologize and withdraw like countless young attorneys before her? Miss Crockett, Stone said, his voice dripping condescension, let me clarify something. In my courtroom, we handle facts and law, not political narratives. If you cannot distinguish between legal advocacy and activist rhetoric, perhaps you should reconsider whether federal practice suits you. Stone paused dramatically, letting his words penetrate. He surveyed the courtroom as if addressing the entire legal profession. I've presided over this bench for more than a decade, and I've witnessed too many young attorneys who believe passion can replace preparation, who assume volume can substitute for legal reasoning. His voice grew even more condescending. Miss Crockett, congressional representation doesn't make you a constitutional scholar, youth doesn't make you progressive, and speaking loudly certainly doesn't make you correct. That crossed every conceivable line. Stone wasn't merely attacking her legal arguments anymore. He was launching personal, professional, and political assaults. He essentially told a sitting congresswoman and Harvard-educated attorney that she didn't belong in federal court, that her age disqualified her, that her passion invalidated her expertise. The courtroom's silence became deafening. Court staff studied their desks. Attorneys stared at their hands. Everyone awaited whether Crockett would crumble under pressure. However, as Stone settled back with that smug smile, believing he'd just terminated Jasmine Crockett's legal career, he had no idea he'd just awakened something extraordinary. Crockett stepped closer to the podium, her voice clear and unwavering as she looked directly at Judge Stone. Your Honor, with complete respect, I must address what's occurring in this courtroom today. Stone's eyebrows shot upward. Nobody had ever begun responding to him like that. You've questioned my experience, my competence, and my right to practice before this court. You've suggested my client's claims are frivolous without hearing our evidence. You've implied I'm presenting political rhetoric rather than legal arguments. The courtroom froze. Every person present realized they were witnessing something extraordinary. Your Honor, I graduated from Harvard Law School. I am a licensed attorney in good standing. I am an elected member of the United States Congress. But most importantly, I represent American citizens whose constitutional rights have been violated. Stone's face reddened. He wasn't accustomed to such direct challenges. Crockett continued, her voice strengthening with each word. You inquired about my voting rights case experience. Let me share my experience. I've represented voters who waited 8 hours in line because polling locations in their communities mysteriously decreased. I've fought for elderly voters denied assistance due to language barriers. I've advocated for students whose campus polling locations disappeared the week before elections. She paused, allowing that to register. Your Honor, you mentioned this court operates under different standards. You're absolutely correct. This court operates under the Constitution of the United States, which guarantees every American citizen voting rights regardless of their zip code, their income, or their skin color. Stone attempted interruption. Miss Crockett, I don't need civics lessons. Actually, Your Honor, I believe you do. Audible gasps filled the courtroom. Nobody spoke to Judge Stone like that. Crockett retrieved a folder from her briefcase. Because if this court truly operated under constitutional standards, you would understand that the Supreme Court in Shelby County versus Holder didn't eliminate voting rights protection needs. It actually made cases like ours more important, not less significant. She opened the folder and began reading. In Anderson versus Celebrezzi, the Supreme Court held that voting represents a fundamental right that cannot be infringed without compelling justification. In Burdick versus Takushi, the court established that any law restricting voting rights must be narrowly tailored to serve compelling state interests. Stone's mouth hung open. This wasn't following his expected script. In Harper versus Virginia Board of Elections, the court ruled that wealth cannot create voting barriers. In Dunn versus Blumstein, the court struck down unnecessary residency requirements. Should I continue, Your Honor? Crockett was just beginning. You suggested I haven't personally verified my client's claims. Let me tell you what I verified. I verified that Mrs. Rodriguez, a 67-year-old grandmother, was denied voting because her address didn't match her ID exactly, despite living in the same house for 30 years. She turned to another page. I verified that Mr. Johnson, a college student, was denied voting rights because his campus polling location closed without notice, forcing him to travel 40 miles to the nearest location while working 2 jobs to pay for school. I verified that Miss Washington, a single mother of 3, couldn't vote because she couldn't afford time off work to wait in 4-hour lines caused by reduced polling stations in her district. The courtroom remained completely silent except for Crockett's voice. Turning the tables, judicial ethics lesson. Your Honor, you asked if I personally verified these claims. I've done more than verify them. I've lived them. I grew up in communities where voting was a privilege you fought for, not a protected right. Crockett looked directly at Stone, her voice unwavering. You mentioned I should distinguish between legal advocacy and activist rhetoric. Your Honor, there is no distinction when the law itself demands justice, when the Constitution itself requires equal protection under law. She pulled out another document. The Federal Judicial Code of Conduct requires judges to avoid even the appearance of bias. Canon 2 states that judges should respect and comply with the law and should act at all times in a manner that promotes public confidence in the integrity of the judiciary. Stone's face went pale. She was quoting judicial ethics rules to him. Canon 3 requires judges to perform their duties fairly and impartially. Your Honor, questioning my right to practice before this court based on my age, my background, or your personal opinions about civil rights cases violates these fundamental principles. Furthermore, Your Honor, you asked if I was suggesting this court has been complicit in discrimination. I'm not suggesting anything. I'm stating a legal fact. Any court that dismisses civil rights claims without hearing evidence, that questions attorney qualifications based on personal bias, that creates barriers to constitutional protections, that court is not upholding its constitutional duty. The silence was deafening. Your Honor, I took an oath as an attorney to uphold the Constitution. I took another oath as a member of Congress to protect and defend the Constitution. Today, I'm keeping both oaths by standing here and demanding this court do the same." Crockett closed her folder and looked directly at Stone. "You suggested that perhaps federal practice isn't right for me. Your Honor, I would suggest that perhaps it's time for this court to remember that justice isn't about protecting judges' comfort. It's about protecting citizens' rights." She paused for effect. "My clients didn't send me here to be polite to power. They sent me here to speak truth to power. And the truth is simple. Every American deserves voting rights, and every court in America has the duty to protect that right." Judge Stone sat there, his mouth slightly open, his usual commanding presence completely deflated. For 40 years, nobody had ever challenged him like this. Nobody had ever quoted judicial ethics rules to his face. Nobody had ever turned his own intimidation tactics against him. He gripped his gavel, but for the first time in decades, he didn't know what to do with it. "Your Honor," Crockett concluded, "I'm ready to present our evidence whenever the court is ready to hear it, because that's what federal courts do. They hear evidence, they apply the law, and they protect constitutional rights. Everything else is just personal opinion." The courtroom remained silent as Stone struggled to regain his composure. But everyone present knew they had just witnessed something historic. The moment a young black woman from Texas gave one of the most powerful federal judges in the state a constitutional law lesson he would never forget. For 30 seconds, that felt like an hour, Judge Stone said nothing. His face cycled through emotions, anger, embarrassment, and something that looked suspiciously like respect. Finally, he cleared his throat. "The court will hear your evidence, Counselor Crockett." That was it. No apology for his earlier hostility, no acknowledgement of his inappropriate behavior. But everyone in that courtroom knew what had just happened. Jasmine Crockett had just forced one of the most arrogant judges in Texas to back down. As Crockett began presenting her case, something remarkable occurred. Stone actually listened for the first time in the entire hearing. He took notes. He asked legitimate legal questions instead of launching personal attacks. The transformation was so obvious that veteran court reporters would later say they'd never seen anything like it. Within hours of the hearing's conclusion, the legal community buzzed with news of what had happened in Stone's courtroom. Sarah Martinez, a civil rights attorney who had practiced before Stone for 15 years, couldn't believe what she was hearing. "I've seen Stone destroy careers in that courtroom," she told colleagues at the Dallas Bar Association. "I've never seen anyone not just survive his attacks, but turn them around on him like that." Professor David Kim at SMU Law School was teaching constitutional law when news of the hearing reached him. "Class," he announced, "we're changing today's lesson plan. We need to discuss what happened in federal court this morning because it's going to be studied in law schools for decades." Within 6 hours, legal blogs were posting transcripts of Crockett's response. The hashtag #, Crockett versus Stone, was trending on legal Twitter, with attorneys sharing their own stories of judicial bullying and praising Crockett for standing up to it. Not everyone in the legal establishment was celebrating. Judge William Hayes, a longtime colleague of Stone's, defended his friend at a judicial conference that evening. "Andrew Stone is a respected jurist with 40 years of experience. He shouldn't have to tolerate disrespect from lawyers who confuse activism with legal argument." But other judges weren't so supportive. Judge Patricia Williams, one of the few black federal judges in Texas, made a rare public statement. "Every attorney deserves to be heard based on their legal arguments, not questioned about their qualifications based on personal bias. The Constitution doesn't have an age requirement for civil rights advocacy." Judge Maria Santos, who presides over the Southern District of Texas, was even more direct in her criticism. At a judicial ethics seminar the following week, she spoke about the importance of maintaining courtroom dignity. "When judges allow personal bias to influence their treatment of attorneys, we undermine the entire justice system," she said, though she never mentioned Stone by name. The Federal Judicial Center, which trains federal judges, quietly announced they would be expanding their bias training programs. While they didn't cite the Stone-Crockett confrontation specifically, legal insiders understood the connection. Most significantly, the Administrative Office of the U.S. Courts issued a rare reminder to all federal judges about maintaining civility and respect in their courtrooms. The memo emphasized that all attorneys appearing before federal courts deserve to be treated with dignity regardless of their age, background, or the nature of their cases. By the next morning, video clips of Crockett's response were all over social media. MSNBC legal analyst Joyce Vance called it one of the most powerful defenses of civil rights advocacy I've ever heard in federal court. CNN's legal team analyzed the confrontation, with Jeffrey Toobin noting, Crockett didn't just defend herself. She gave a masterclass in constitutional law while calling out judicial bias. It was extraordinary legal advocacy. Even Fox News legal commentator Jonathan Turley, no fan of progressive politics, had to admit Crockett's legal arguments were sound. She cited relevant case law. She understood judicial ethics, and she made her point without crossing the line into contempt. Like her or not, she knows her law. The Washington Post ran a feature story titled, "The Congresswoman Who Schooled a Federal Judge," detailing Stone's history of hostile behavior toward civil rights attorneys and Crockett's unprecedented response. Back in Washington, Crockett's congressional colleagues took notice. Representative Alexandria Ocasio-Cortez tweeted, "This is what it looks like when you send people to Congress who actually understand the law and aren't afraid to use it." Republican colleagues were more cautious, but privately, several admitted they were impressed. "I disagree with her politics," one GOP member told Politico on Background, "but you have to respect someone who stands up to bullying like that." House Speaker Mike Johnson, when asked about the incident at a press conference, gave a careful response. "I believe all members of Congress should conduct themselves with dignity, whether in Congress or in courtrooms across America." But the real political impact was in Texas. Crockett's approval ratings in her district shot up by 12 points in a week. Fundraising emails highlighting her courtroom confrontation raised over $400,000 in small dollar donations. Law professors across the country began incorporating Crockett's response into their curricula. Professor Angela Davis at Harvard Law School, where Crockett had studied, assigned her students to analyze the constitutional arguments Crockett had made. What Representative Crockett did was demonstrate how constitutional advocacy should work, Professor Davis explained to her class. She didn't just cite case law. She explained why these cases matter for real people facing real barriers to voting. The Yale Law Journal requested permission to publish the full transcript of Crockett's response in their next issue on advocacy and judicial accountability. Perhaps most importantly, Crockett's stand had immediate effects on other civil rights cases. Attorney Maria Gonzalez, representing farm workers in an employment discrimination case, reported that when she appeared before a notoriously hostile judge in Houston, she referenced Crockett's argument about judicial ethics. "The judge actually paused and asked me to explain my constitutional arguments," Gonzalez said. "It was like he was afraid of being the next Judge Stone." The NAACP Legal Defense Fund issued a statement praising Crockett's advocacy. Representative Crockett demonstrated what we've always known, that constitutional rights don't depend on judicial approval. They demand judicial protection. For Crockett herself, the moment represented something deeper than legal victory. In an interview with Essence magazine, she reflected on what the confrontation meant. "I kept thinking about my mother working those two jobs, never giving up even when people told her she didn't belong," Crockett said. "I thought about every young lawyer who's been told to stay quiet, to respect authority even when authority is wrong. Sometimes you have to speak truth to power, even when power is wearing a black robe." 3 weeks after the confrontation, Judge Stone issued his ruling in Crockett's voting rights case. In a shocking development, he ruled in favor of her clients on every major point. The ruling was notable not just for its outcome, but for its language. Stone wrote, "The court finds that the evidence presented demonstrates clear violations of constitutional voting rights. The remedies requested by plaintiffs are necessary to ensure equal protection under law." Legal experts noted that the ruling read like it was written by a different judge. Some speculated that Crockett's constitutional arguments had genuinely changed Stone's perspective on civil rights law. 6 months later, the impact of that Tuesday morning in Dallas was still being felt throughout the federal court system. Young attorneys reported feeling more confident about challenging inappropriate judicial behavior. Several judges had quietly changed their approach to civil rights cases. But questions remained. Would Stone's transformation be permanent? Would other judges learn from his example? Most importantly, would Crockett's stand inspire a new generation of civil rights advocates to speak truth to power? As Crockett herself put it in a speech to the Congressional Black Caucus, "Democracy isn't a spectator sport. Constitutional rights aren't suggestions. And justice isn't something you ask permission for. It's something you demand, whether you're in Congress or a courtroom or a polling place." The story of Jasmine Crockett versus Judge Andrew H. Stone became more than just a legal confrontation. It became a reminder that in America, the Constitution belongs to everyone. And sometimes it takes someone willing to fight for it to make that truth real. Today, law students study Crockett's response as an example of effective constitutional advocacy. Judicial ethics seminars use the confrontation as a case study in bias and fairness. And across America, young attorneys facing hostile judges remember that Tuesday in Dallas when one woman stood up, spoke truth to power, and reminded everyone that justice doesn't require permission. The battle for voting rights continues, but thanks to Jasmine Crockett's courage in that Dallas courtroom, it continues with the knowledge that constitutional principles can still triumph over personal prejudice when someone is brave enough to defend them. Hit that subscribe button and ring the notification bell, because stories like this remind us why we need fearless advocates fighting for our rights every single day. Who do you think will be the next to stand up to judicial bullying? Let us know in the comments below. And don't forget to share this story with anyone who needs to see what real constitutional advocacy looks like. Because in America, the fight for justice never ends. It just finds new heroes willing to carry it forward. The Constitution doesn't protect itself. It requires people like Jasmine Crockett, who are willing to stand up, speak out, and demand that our institutions live up to their highest ideals. When we stay silent in the face of injustice, we become complicit in it. When we speak truth to power, we honor the very best of what America can be. This is why your voice matters. This is why every vote counts. This is why we must never stop fighting for the democracy our founders envisioned and our children deserve.